So let's move to the next one. Another question that we often see is that how this DPD will apply to specific sector and use cases. So while most of the commercials, we understand that it will happen, but say, for example, what happened to the journalism domain. Now, journalism, of course, there is no explicit journalist exemption that was given in 2023 Act. Consent for naming individuals in the reports are also unclear. And how the investigation journalism happens, which court such things as a source-based or provide certain information which they may have acquired through other means, then whether they are allowed to publish, they are allowed to use the PII data, we currently do not know. Second is on the research and academia side also, where are we going to use the anonymized data, whether we will get an exemption for legitimate research purposes. Say, for example, if we are identifying certain trends or certain thought process basis on certain socioeconomic status, will that be allowed? Will we be able to capture certain sensitive information? Currently also it is not known. And then what will happen to the university's archival retention policies is also to be decided. Say, for example, for large consumer tech companies, it is 3 years, or if it is by law more, then the more applies, or the local regulation or the local legal laws supersede this. But for academia, currently it is not clarified or it is not clear for how long they can retain this information. What will happen to children's data? Now, this is also one of the questions that it's mentioned that for child under 18 years, the consent has to be given by parents. So a lot of edtech companies or gaming companies, etc., which might be storing PII data, they have to self-declare currently that this is my parent or a guardian, and then they will get an email and the parent or a guardian has to provide the consent. Now, if you want to establish the relationship, whether it's the right parent or right guardian, it's currently not available, because if that is implemented, then there will be an additional burden of sharing the relationship as well as the PII information of the parent or guardian also. So currently it's based on the self, you can say that process where the child provides the contact details or an email address of a parent or a guardian, and they provide this. So edtech companies who are operating it, it might become challenging if they have to really accept the verifiable parent controls purely by nomination and not go by verifying the relationship with the parents. For the government, yes, there is a section 17 which exempts the government processing, and the purpose limitation concerns is also for the data, and then there is a complexity around the interplay with the amended RTI Act. It does give government a lot of powers which supersede all the regulations, which includes DPDA along with many others for the purposes that they have in this regulation. Another question which comes is that about the AI and automated decisions. Say, for example, training models, can they use it without the explicit consent? Can you give recommendation by using certain analytics without the consent if you are not storing that? And storing it means permanently and identifying with the user. What is the duty to disclose when automated decisions are done? Say, for example, execution of a particular function, if you have given a consent, or if you are browsing and you have clicked certain things which might go and say book seats for you, etc. Now, in this case, the DPDA very clearly says that the use of AI is optional, which means that if you are saying that I need to use the AI for legitimate purpose, and you always give consent for the legitimate purpose, then it might be allowed, provided if you are passing on the savings or disclosing it. Say, for example, I am processing a health insurance claim, and I am using AI to fast track the health insurance claims. So once you upload the claims, and if all the documents are in order, the AI scans them. And instead of, say, it takes 4 to 5 days to process a claim by verification of the documents, which includes doctor prescription, 24-hour hospitalization, the disease, the coverage in the policy, and the appropriate invoices and test results, etc., then I approve. But if I use AI and I can approve it within, say, 6 hours or 8 hours, then probability is that you might be able to prove, and hence you might be able to use the AI because it is being used for legitimate purpose. And if by the way of this legitimacy, it is also learning in a deduplicated way about how to compute a confidence score to process the PII data faster, or to learn and then make it more accurate, then it might be allowed. So let's see the next one. Significant data fiduciary classification. As I was mentioning earlier, that the definition of a significant data fiduciary is not mentioned, which means that what is the volume and sensitivity criteria? Is it like 1 million records? We currently do not know. Or there is a risk-based classification framework, just like GDPR has that, whether we are going to apply to that, which means that we might have only 50,000, say, records of sensitive PII, but there is a huge risk because, where it is stored and how it is being used. Then will that be considered a significant data fiduciary, or it will be pure volume, which means that banks or insurance companies or large consumer tech companies who have millions of PII data, only they will be classified as data fiduciary. So large consumer-facing platforms may be auto-designated. That's what we believe. Potential sector-based triggers also will depend on the nature of data processing. Say, for example, all banks, all financial services, NBFCs, or insurance companies, or tech companies with generally might come there because they typically is believed to have millions of PII data with them. Now, are there any obligations if you are a significant data fiduciary? Whether the obligations are there, obviously you have to appoint an India-based data protection officer. You might have to conduct an annual audit by an independent auditor. Whether it will be through empaneled or you have the right to choose, I believe that currently there is nothing which is giving that it has to be empaneled. It can be any data protection audit by an independent auditor, and the firm might have the right to choose any of the privacy, legal, or data privacy firms who can do the audit. And if you are significant data fiduciary, one of the mandate is also to perform the periodic data protection impact assessments. At least periodic means once in a year, and if it is too risky, currently the framework is not there, or might be when there is some significant change happens in your collection, then you can have a risk assessment done. And obviously there will be more and enhanced security and compliance requirements against which you will be seen it. So what are the action? Action is that we have to design the data architecture and governance to be significant data fiduciary ready in terms of everything what we do. As much automation we can do is better, because doing DPIA or getting consent from millions of users and tracking it with the revocation or leveraging AI or personalization and tracking every activity will be extremely difficult if there is no automation being done. Hence, the complete life cycle of the data collection to processing to usage, consent management to impact assessment, and then breach notification, almost all of them needs to be automated. Data breach notification requirements, that's another one. So key question is that, yes, we need to report within 72 hours, but when does the 72 hours starts? When the data breach has happened, but what if you do not know by your own detection mechanisms? So the 72-hour deadline obviously will start when you will know that a data breach has happened. But the important point is also that should you report every data breach? Say, for example, an unauthorized access has happened internally, which means that I inappropriately was supposed to send a file to finance department. I send it to HR department and they opened it up. Will it be considered as data breach? The answer might be no, because it does not have an impact. It might have a PII data, which you can follow internal process of classifying the data breach, and maybe you will put up in a policy that a critical and high risk data breach only will be notified. And what does it constitute is that maybe the scale of the breach that has happened and whether it has happened outside of it, which means it's not in your control now, and then hence to be notified. So what is the threshold currently for notifying data principals is also not known, which means that if the breach has happened, we know that say 100,000 PII data has been exposed, and we have to inform the data principals, then what is the threshold? It is 10 or it is 100 or 1,000, or it is just what the DPP says. It is also currently unclear. So what we should do is that as an organization, we should define a breach severity metrics and classification criteria, and then put up in the policy about when and how we are going to report the data breaches, and develop the notification templates which are ready to deploy so that it can have certain holding statements and be informed accordingly. And then if there are third-party breach flow downs, say for example, if it happens through processors, which are third parties who are processing PII data on your behalf as a fiduciary, or if there are certain third-party vendor contracts who are leveraging it for training purpose or for delivery of a services, then they also need to be included so that the data breach in their setups, which has happened where you are the data fiduciary of that PII data, has to be informed. And you can simulate certain breach, and you can also put up the appropriate detection and corresponding forensics mechanism to maintain an audit trail. Okay, so data retention period. Well, currently it says 3-year retention for large e-commerce companies, and there is to be 48-hour pre-deletion notices which should be given to the users. So the users are inactive, 3 years have passed, you want to delete the data, then you can give the 48-hour pre-deletion notification. And there can be for certain things purpose-linked data retention, which means that data should be deleted ideally even before if the purpose is already fulfilled, because you are collecting all the data that is required to provide a service, and there can be additional service which is asked, which might need additional data. But if on an ongoing basis that service is not required, then that particular data purpose is gone and has to be deleted. And you can have automated deletion workflows so that you can ensure compliance at scale, which means that post retention it deletes automatically from all the sources. It can be the sources on the disk, or sources on storage area network, or storage on a subsequent backups also. Now, what is the key conflict here? Key conflict is that for many banking and tax regulatory purposes, you might have to retain all transaction informations and account information for 7 years. So it exceeds 3 years. So definitely whatever conflict we have with respect to other legal liabilities and regulations, then they will supersede this, which means that you will store for 7 years or plus and not delete it. Similarly, RBI data retention rules also are relatively different versus what DPDA says. So again, the regulatory requirements of RBI will supersede here. Now, how to handle the legal holds during ongoing or anticipated litigations, which means that what if something is already going on, or if you anticipate that I will have certain litigation because of a particular case, then yes, during those cases, if you have the appropriate intent and you document it, then you will be able to justify, say, retaining data for longer than what the time permits. And then there has to be a sectoral harmonization framework, which is not yet established by different regulators. I think this is not going to be an easy task because there are too many regulators, say, separate for banks and for insurance companies, or for telecom regulatory authorities, and now for electricity and power distribution to now national critical infrastructure is also coming to the place on it. So forth. Then interaction with other laws. One of the question is that how it will interact with other laws, the IT Act, and what if there are conflicts, like we were just discussing, what will happen in case of journalism, or what will happen if RTI Acts, which is also now amended, so if there is a direct conflict between individual privacy and public transparency, then what will happen, which means that if I ask that who was awarded and contract and who are the people, say, whose name were deleted, etc., as a part of RTI, if you have to tell me, then whether it will comply to a DPD or not. So that is yet to be seen, that what situations arise where we need to tell the PII data in certain contracts or certain government duties, like payment to made to a few people because of certain sections that is invoked, or certain benefits that were being provided, and will it be challenged because it will contain PII data of those who were the beneficiaries. And similarly, RBI and SEBI rules also are mandating certain banking and financial data retention mechanisms, and they can only be done if they can correlate or they can attribute this to some person, which means that we need to hold that information. And lastly, Section 38 provides the DPDA supremacy over other laws, but practical harmonization is not clear. As I said, that if it's a regulation like an RBI, then probably ATA retention process will definitely supersede, in my opinion, though I am not a lawyer. Tax records for 7 years also needs to be extended, so it will be beyond 3 years. Telecom Regulatory Authority also has certain stringent subscriber requirements for them. Then enforcement and practical compliance, where there will be any grace period. Currently, it is not known. In fact, what we were reading in the newspaper, it states that actually it can be compressed and people might need to be asked to comply in a relatively lesser time frame rather than 18 months. How will Data Protection Board prioritize complaints? Again, it is an open question. It may be depending on the size, scale, and risk of the complaint that has come. And if it is complaints which are individual versus, say, a complaint for against a particular company for a certain mass deletion of practices, that might also depend on that. Currently, we do not know the form, so we don't know what all fields are being asked for and how those fields will decide the prioritization. Which compliance framework or certification will be recognized? Again, there is no particular compliances. You might be, say, comply to ISO's privacy regulation 27000, but you still might not necessarily be compliant to all the DPD Act. So certification to GDPR or certification to ISO certification on privacy might not guarantee that you are compliant. Will there be a compliant or explain approach initially? Maybe, but currently it is not mentioned anywhere. And if cross-border enforcement works for large multinational companies where certain data is being transferred, then in which I think jurisdiction will largely depend on who are the principals and where to reside. So let's go to the next one. Is DPD applicable to captive centers who are not processing the data locally or exempt the employees? Answer is yes. Largely only for the employers. They can issue privacy notice to all of their Indian employees because they are storing their data. Otherwise, whatever they are doing for the other purposes, like captive center of, say, a large multinational bank who do not operate in India, which means that other than the employees' PI data, there is no data of other users. All the other users' data is only getting processed in some captive centers. It's a call center or a BPO or a KPO is different. Okay. Then what does a European MNC compliant with GDPR? Yes, so if you are in Europe, yes, there are certain differences. So for example, for the baseline for GDPR, a children's age threshold is 16, or there is even 13 in certain countries, but here it is 18. So it's possible that you might be compliant in Europe if you are, say, a mobile gaming company, wherein a 16-year-old person is considered as adult, but here it may not be, and you may need to change and get an additional compliant or verification by a parent. Consent manager, there is no concept of consent manager in GDPR baseline, but then in DPDA, you need to have an integration with the designated consent manager infrastructure so that you can hold that and you can define consent manager. Local language, again, it is required in official EV language. In privacy law, it is clearly mentioned that it has to be required in all Indian regional language supports where you operate, and then it's there in 8 schedules. So if you operate in all over India, maybe you might have 27 to 28 different languages in which you have to put up your privacy policy onto your portal. On the governance, it's EU-based DPO. Here it will be India-based DPO for SDF. For other grievance officers will be required. Cross-border transfers are based on adequacy decisions, while here it is allowed unless blacklisted, which currently we don't know. The breach notification is 72 hours. Specifically for high risk, here the notification has to be on data protection board and also the affected data principals. But what's the cap? Currently we don't know. The data retention has to be purpose linked, while it is mentioned 3 hours and 48 hours of a notice. So there are few changes that even if you are compliant to GDPR, you might have to comply to. So that's all I have in this particular presentation. Thank you and appreciate. Do let me know any feedback and look forward. Don't forget to like, share, and subscribe, and also press the bell icon to stay notified of all the future released videos. See you in the next one. Thank you.